Sarah, what's the status of the bionitrogen or the Railspur grant? Is it up for renewal this time? So we have to go back before the EDA and renew the Railspur grant, which is different than changing it. I just wonder if we should just resubmit. We have time. I mean,
Those are all things that I think we could flesh, we could
but we
handle.
only
but
have time. The funding cycle ends in 2 weeks.
The application deadline.
Yeah.
I mean, we could submit the application, so the board wouldn't have to necessarily.
Well, maybe we should withdraw that, our portion of that, and let you submit your own application to the EDA.
Well, I'd get scared when we start withdrawing anything, but
But the way it's
but
working.
anyway, a conditional withdrawal maybe or something. But
Well, technically, if it's already an approved designation, does it have to be, I mean, it could be updated at any meeting. It doesn't have to be involved in this funding cycle, I wouldn't
Yeah.
think, or.
It's up for renewal. There's an expiration date on all grants. The expiration date is coming up for this particular grant. So we do, at their next meeting, we are required to let them know if we want to extend the contract and renew it or choose to
But if we,
concede the grant.
if we did renew it and wanted to come back at a later meeting and change some aspect, then that would either be on us to present that to the EDA or on bionitrogen to present what we want to change. Is that correct?
Is that correct?
No.
The current grant that is up for expiration of bionitrogen, if we extend that grant, can we come back at some point with either bionitrogen or the IDA to change the aspects of the grant?
That would be up to the board. But yeah, I mean, you can amend, these are amended contracts.
So if we put the renewal application in the packet, then upon presentation, we can amend, and we can certainly take care of the name change at that time and amend that. But can we, what else? I guess we can do whatever they ask, whatever we ask them to do. They can do whatever we propose or not.
I have some additional questions. You know, I understand with the bond issuance of these feasibility studies that are taking place are required for the bond. When we initially awarded the $1 million, and I believe for the EDA as well, we really did not go through a vetting process of any form, because it was essentially, you know, we're gonna bring this much money to the table and you're gonna put a much smaller amount in with that money. So, you know, the risk for us was significantly lessened in making that commitment. But
What do we actually approve, though?
I believe that we approved that our money would come after.
Initially, it was we'd reimburse them, and they came back to us and said, can we do a pro rata matching? And then they came back to us and said, can you give us some money up front? We said no.
Correct.
We've only had one grant award at the board. I mean, I know there's been some discussion, and sometimes we only had one grant award, and we've never modified or amended the grant award.
But you have an appropriation from the IDA.
Right, there was a minute, the IDA had requested an appropriation from the EDA prior to the IDA entering, awarding the grant to bionitrogen, and there was a grant award modification at the EDA level to be consistent with the IDA grant award agreement. But we've talked about this project for a long time, I understand, but we've only really had one grant award agreement, and it is the grant award agreement that we have now, which the terms of that agreement were a pro rata contribution with respect to the bond issue, the bond draws. And we have, last time we were here, we talked about potential ways to modify that to provide a greater inducement for the project, and that's still the position that we are in. We don't have a presentation with you today. We really wanted to have a clean discussion on the bond inducement, so understanding the project requires all the components, but we're happy to discuss anything, but there are specific issues to that, and it's a standalone part of the process. And so, at least it was, and perhaps it was my fault for not being more prepared to have a more robust discussion, but just from the interest of time and having, preparation for the meeting, my intent was to try to have a clean discussion on the inducement resolution so that we could get some action on that. And then we would continue to work. And so, but I'm glad you did ask the question on the vetting, because I would really like an opportunity to do that. We've not provided any format of request for information on what that looks like. So I understand there's a need for vetting, and I wanted, there's due diligence that this board has talked about doing. So tell me what you want. I mean, we're happy to go. We're chomping at the bit to get that process done if it holds things up. But I don't think you want me designing the vetting process for us to do that. If you do, then just tell me, and I'll be happy to tell you what you need to know. But I'm sure that's not going to be so satisfactory. But there is, we need some feedback on that so that we can get that underway and not. I mean, like I said, not be coming here every month for 3 or 4 months and not getting anything done. I mean, there are schedules that we need to maintain to make this thing go. So if we're going to start, we have to start knowing that we're going to be knocking those things down going forward, or else we just need to wait to start or not start. I mean, that's really the practical aspects of their process.
And I guess the general thought on that, or bringing up the vetting, is just if we are going to change how we initially agreed to award that $2 million along with the EDA, then we need to change the process and
Absolutely.
go a little further and a little more detailed. But I realize that's not, the
No, but I
discussion
mean,
on
it's
the
important
table
because,
today.
again, I don't want that to be sitting there for months and then nothing happening, and you not wondering why we're not coming back to talk to you, and us not wondering why you're not asking us for information. And so does need to be robust and consistent communication on that process, so that, like I said, once we start, the clock's ticking, we need to be able to keep knocking down the dominoes and making the thing move forward. Because, as I say, we've had some issues in the past getting that process going, but we're at the point now where we're ready to, we want to go, but when we go, we need to, we want to be in that mode of, if everybody's engaged and moving forward, that we're getting progress made too. I mean, I think everybody wants to see that happen. So.
And, and another thing, back to Ken's point, we need to ensure that, we know all of the expectations on our part, what liabilities this might bring for us. I understand that, Mr. Cunningham said there wouldn't be really any recourse for us if, something did not take place in that process. But I do think it's wise to suggest that we get, someone who specializes in these types of occurrences and can advise us. But I would certainly like to see us, get an opinion on that, so that once again we can, flesh this out and move forward.
Madam Chair, one solution, they have a time sensitivity issue, is what I'm hearing. We want someone else to look at it issue, and perhaps if the board is willing to consider a special meeting, you can deal with both. This is not extraordinarily lengthy, and for someone in the area that knows what they're doing, I'm sure can look at it and get comfortable with it fairly quickly if the board would be willing to hold even a special meeting or one agenda item or something and take it up and deal with it.
So
Advertise and deal with it, so that we're not waiting a whole nother month to come back before you
Sure.
to
So
address
that's
it.
kind of back on you. How quickly do you think that you can
I
do
think we-
that, and also what kind of cost you think we're talking about?
Typically, the council expense is not really a thing that you get invoiced for, that you have to worry about the budget impacts. Mr. Cunningham, correct me if I'm wrong, but most of the council fees associated with this stuff are paid from the bond issue. So even council representing us, reviewing all this stuff for us, are paid from the bond proceeds. So it's not anything we have to be concerned with as far as budgetary impacts immediately.
Did Taylor or Hendry County use an outside counsel for advice?
Yeah, that's actually a very good question in light of this timing. When we first went to Hendry, we were in November of 2013. We had to take certain steps in order to get in position to go to the Division of Bond Finance to get the volume cap in 2013, because Florida had $800 and something million unused that was going to be wasted unless we could get in line with $300 million. The county attorney of Hendry County had done a bond issue with a firm called Neighbors Giblin, which is in Tampa and Tallahassee, a well-known local government firm in the state of Florida. They brought in Danny Tyler to work with us and actually structure this exact same thing that you're looking at today. So Danny is actually the issuer counsel to the Hendry County Industrial Development Authority, who actually worked with us to do all of this under Florida law, is very comfortable with the process. In Taylor County, we've got a situation where they are just relying on their counsel in place, like the county attorney or whatever. The city of Perry is also very interested in that, in the $5 million grant in Taylor County, and they have their own attorney who is working with us to assure that that's done properly under Florida law. So there is a bond attorney at Neighbors Giblin that has blessed this in Hendry, and we offered last week to see if we needed someone to come in this role that would be paid for bond proceeds, but we never had any responses whether you really needed an attorney or was just going to use Ken or whatever. So hence we're here today in this situation.
I never received that communication, so.
Okay.
Neither here nor there, I suppose. I mean, if the board's willing to hold a special meeting, my preference would be to use someone from the outside. Neighbors Giblin is a firm I'm familiar with. I know they have the experience. There's a person over there that I've consulted over the years. It's not Danny Tyler, but he is bond counsel. I guess probably down the hall from one another or something.
Sure.
That may end up using the same person. I don't know. I just want someone to look at it, feel comfortable with it, bless it, make certain that I understand it before we put it in front of the chair for signature.
So what time frame do you think you need? 2 weeks?
I mean, I think a couple of weeks is fair. Is that?
I mean, I can't imagine that somebody that knows what they're doing wouldn't be able to get up to speed on this very quickly. So 2 weeks
Yeah.
of notice and stuff, I can't
I mean,
imagine. that would-
2 weeks allows for the advertisement for the notice for the special meeting, and I think gives plenty of time to look at it. There may not be any major changes to it. I'm pretty comfortable, but I just, it's a very specialized field. I mean, it's what I'm taking Mr. Cunningham does almost exclusively. So it's a very specialized field, and
It is, and I'd recommend, if you want to go that route, just bring in Danny Tyler, who is going to recognize this immediately and not spend a lot of time and effort reinventing the wheel, because he was part and parcel of this and recommended passage in Hendry County. So.
Yes, say something real quick. For the record, Donnie is correct in the process. Hendry County, as from the history, they had not issued, or the city and the county attorney or the development authority attorney had not done a bond issue in quite some time. And as you said, it's specific. So the last bond issue they did, Danny was the special counsel. That's why they brought him in. In the case of Taylor County, they're actually going through a bond issue process, so they're familiar with it. So it really is up to you all to decide that, and we're not trying to force you one way or the other. It's a case-by-case basis, but Ken is right, it's very specific. So having somebody that's familiar with this process would save, I would imagine, a lot of time and resources from your side. Whoever that is fine, and Donnie has a lot of recommendations if Ken would like to go through them. The other thing that I would like to say is that it is a process. As I said, this is an inducement. You're not passing something that is stuck. This is starting a process, and we're trying to restart the process in a very pragmatic way, in a way that has already been done by 2 other counties. So we do have an application questionnaire that was submitted to Hendry County, an application questionnaire that was sent to Taylor County. Similar information that is probably outdated was sent to the EDC here as well. So we are happy to go through a vetting process. Some of the information is going to be presented to Deutsche Bank, so there will be some confidentiality issues, which I'm sure we can work through, but we're trying to provide you all the information we can so that you can make an educated decision as a board. And one of the things that I would like to state is we've specifically put a packet together that we sent to everybody, which has all of the publicly available information on state level entities and county entities that have vetted this process over the last 6 to 12 months. From the governor's office to the Division of Bond Finance to the Department of Economic Opportunity to Florida Development Finance Corporation to 2 different development authorities. So we're happy to provide the information with you if you can. We're just trying to show you that other people have already started this process and it's a tried and true path.
Thank you for the clarification. Any other discussion from board members or questions? So we have a couple of options. At the advice of our council, we'd like to consider a special meeting to allow 2 weeks for Ken to seek outside counsel and review and make a recommendation. We could also, we have the option to go ahead and approve the inducement. What's the pleasure of the board?
I move we get Attorney Evers to find a company to approve the bond issue and all, and bring back to us, and let's schedule a meeting in 2 weeks to go over the results.
So tentatively, we can go ahead and,
Can we continue this? Would it be better to continue this meeting, or do we want to read?
What's that?
What's a bond hearing? So we have to have,
it's not a bond hearing.
well, thank you.
And just talking with Ken also and Lex, the EDA meeting is on the 27th.
On the
And,
22nd.
and so kind of goes with everything up here before the board, making this decision as well as asking Ken, we do need some direction today on how to handle the existing EDA application that has already been awarded, and decide how to handle that since they do, new applications are due on the 31st. So even if the direction is just that the board directs the director to work with Bionitrogen to come up with a decision on whether or not they're going to submit their own application and how we're going to handle the extension of the existing grant award agreement that we have.
Do you know what time their meeting is?
8:30.
I want to make sure I understand what, I mean, we're going to reschedule an IDA meeting to handle this inducement resolution. I guess, I mean, the other issues I understand are things we need to work through. But I guess my concern is that, again, we're not, using a sledgehammer for a fly swatter, on something, this inducement resolution. If we can have a clean conversation about this inducement resolution, understanding that we're going to move forward on that issue. And if it's a convenience issue about scheduling, fine, but having a joint hearing or something with the EDA to do this inducement resolution, I think would just be asking for too much confusion and complication. So.
I think we were just looking at.
Okay. I just want to make sure I understood what the significance of having this at the same time as the EDA meeting is.
Well, I mean, it is two different issues, but just looking at that date, probably will not work, and I don't know if that needs to, if our activity needs to precede their activity.
I don't think there's any
I'm not
significance
sure.
about the timing of those two for purposes of this, at least.
So do you think, Ken, would it be an issue for us to possibly meet later after the EDA meeting would normally take place?
I don't see the issue. I mean, the EDA meetings normally conclude within the morning. I don't know if, Lex, I don't recall one ever going past noon that I can recall. Are you suggesting maybe a 1 or 1:30 IDA meeting of the same day?
Yes.
I personally think that works. I don't know that that conflicts with anything.
And then we can take up, the issue of how we're gonna deal with the application as well, but, okay, so for the issue on the table, we have, a motion to direct Ken to seek outside counsel, to review and make a recommendation on the inducement proposal. I don't believe we've had a second yet, unless I missed it. So, the motion was made by Mike Prescott. Do we have a second?
You read the motion one more time.
The motion was to direct Ken to seek outside counsel to present to us in 2 weeks. Any further discussion from the board on just the issue of the inducement proposal? Do we have any public comment on the inducement proposal? Henry?
Henry Coleman, Fort Greene. Southside Council reminds me of Waste Generator Products. Mr. Evers. Here's the way I would do this. If they, obviously this company is serious about something. They're in Louisiana, Hendry, Taylor County here, talking about 10 plants. They've been here at least a half a dozen times. The way I would do it is if they've already stepped through this process in 2 other counties, instead of getting outside bond counsel, I would go talk to those other counties, find out what they did. Chances are they seeked outside bond counsel, find out what they did. Now the questions from the public standpoint I would have for this company on issuing bonds in the name of the IDA, the question I would have is, has an IDA ever been sued by an investment group or a bank or anybody else, or maybe not in accordance with 159, doing everything exactly according to the book, which for this IDA would be the first time ever if you actually vetted bionitrogen. It would be an absolute first time ever anything like that ever happened. And I can give you a list of projects about 20 long
I'm
where
sure you
nothing
can,
was
but
done.
Keep it to the topic, please.
The feeling I'm getting on bionitrogen is for some reason Mr. Lambert and the chairman and Mr. Evers, they don't like bionitrogen. I mean, they've stopped they've put cold water on this every meeting. Now, I know for a fact, she said you got 1.7 million bucks in the bank. Use it. Let the EDA grant go by the wayside. Give them your 2 million bucks. Build a rail spur. You know what I would do? They own 610 acres out there. I would have them put that up as collateral. I would also have them say, they only said they needed 40. I would say, hey, you let us use the other, whatever the balance is. We're gonna put a rail spur all the way around that. That's gonna be an industrial park. We're gonna put Florican right next to the outlet of the urea plant.
Final comments.
And that's what we're gonna do. Now, I would really check about this lawsuit stuff. If you start putting municipal bonds out with your name on them, I think there might be some jeopardy. I mean, that would have to be indemnified. Thank you.
Madam Chair, Henry, and if we didn't hire outside counsel, you'd be critical of that as well. So,
You're not,
you
you're
know,
not the first.
Mr. Cunningham, is it extraordinary or out of the ordinary for issuing agencies to hire outside counsel to advise on these matters?
It's absolutely fine to do that.
Did Henry and
Protect
Taylor
your-
do it?
Yes.
Hey, just
Yeah.
call them up.
I just told you.
I'm on your side. Call them.
We're not gonna have comments from the audience.
Just a couple things. One, if it's a cost issue, the cost of that counsel is paid for through the bond proceeds. It's implicit. It's not a question, it's just a fact. So it's completely the issuer's decision if they use bond counsel or if they have a separate issuer's counsel. And both cases, either way, if an issuer's counsel is chosen, the proceeds are paid for. So it's not a question of whether the IDA is burdened for that cost. From a financial perspective, not a legal perspective, Deutsche Bank is not going to invest $300 million and then go after a rural county's development authority because the funds were not paid for or used appropriately. I guarantee you the legal fees that we end up paying in the bond counsel, they make sure that the I's are dotted and T's are crossed to go after other people. That's the process. So they're not trying to go after a board. This is not a legal perspective, it's a financial perspective that they're going after somebody to make sure that the process is there. We have a 25-year contract and that's what they'll go after.
Henry, I normally don't respond, but I'd like to respond to a statement you made, please.
I get to rebut.
Fine. There are some inconsistencies with this project. It's been going on for several years now. And, you know, all I can do is be an observer and watch various things that have happened. I'm still unsure as to the status of the real estate that this project is to be located on. And I think that the things I'm aware of are probably also known by most of the people in this room. I don't know that there's anything illicit about the status of the land purchase, but the things that were represented to me repetitively by this company have not happened. We've heard today, and it's not a revelation to me, but their initial bond issue has expired, and they've come back to apply for a new bond issue. But we've got name changes. They had told us 6 or 8 months ago that our cost of electricity in this community was too high for their project to be feasible. The same supplier is still going to be supplying electricity to the project. I have concerns about whether or not Peace River Electric is now going to be competitive with their price per kilowatt hour as opposed to Duke or Florida Power and Light, who do not have an ability to serve this project without some kind of special dispensation from Peace River Electric. There were issues also cited with the site development, that the land underneath this site was going to require an increase in construction, and that it may have to be built on piers and pilings, and it was going to drive up the costs. And, you know, I'm just sitting here watching all of these circumstances that have continued to pop up with the project, and I think we have every right to raise some concerns about its ultimate viability. And if the good faith and trust of the Hardee County Industrial Development Authority is going to be placed on a bond, whether we're obligated or not, I think at some point we have to feel some obligation to the bondholders or the people that are going to be buying those bonds, or in fact to the people that will be buying stock based on what BioNitrogen says about the Hardee County Industrial Development Authority. Those are issues that really concern me. They're real. They do occur. Thank you.
Henry, please take your seat. We're not going to get into a public debate on the matter.
It's
We're not
important.
accepting comments.
You
Thank
wanna hear it.
Let me also say to address comments, to restate what I said earlier, that I, for one, am excited that there's another possibility for us to move forward with this project. I think the issues of how we're going to allocate the $2 million are separate issues, and I'm excited to see something else brought to the table that we can consider. So having said that, do we have any other public opinion? If not, we have a motion on the table to direct our attorney to seek outside counsel and bring us back an opinion in 2 weeks. Motion been seconded. All those in favor?
Aye.
Anyone opposed? Motion carries.
I'll take issue with that. I told him you'd cut the throat.
We'll have to come back to the board with, when we can potentially have a meeting. We'll just say initially that we'll be looking at possibly the afternoon of the 27th to keep it on a Tuesday in a 2-week time frame. We do still have the issue, as Sarah mentioned, of renewing the EDA grant that's in place, and that, as I'm understanding, will need to be addressed at the meeting on the 27th. Is that correct? Does anyone have direction on how they would like that to be renewed? The options are for us to just renew as is and then address any changes at a later date, or to have BioNitrogen apply for the application.
I mean, BioNitrogen's willing to submit an application, that's not an issue. However, we want to coordinate that, and if this board wants to, we don't need to have competing applications is what I'm trying to say. So that's the only comment I wanted to make, is that if we need to do it, that's fine, but we wanted to do it in concert with this board as well.
Any comments from board members?
We will follow through with renewal or whichever.
It makes sense. makes sense to me to have them submit the application in coordination with us, and that way they get exactly what they need to go forward with their business. We just work with the EDA to make sure there's not repeating.
That application then will be presented without your permission. Because it will happen before,
But it'll also be application from them, not from us.
then we won't renew,
So we wouldn't-
we won't renew the one we have and let them apply directly. Is that what you're saying?
Yeah, but our
We will continue to leave our
our
budget.
non-renewal would be conditioned upon them getting theirs passed. So I would say if we jointly go in front of the EDA and say,
Okay.
Florida, Bionatics is going to submit this application, if you approve theirs, then we withdraw our renewal.
I mean, I'm not, having not had to discuss this issue with clients or before, I mean, to me, my kind of, as I'm thinking about this, the cleanest and easiest way to do it would be to renew the existing application, and that way, you know, your position isn't jeopardized with respect to bionitrogen having the application, and there's flexibility to still to amend it as we did before. I mean, the original application was an IDA application that was a spec building that was not designated to a project. And so, you know, the IDA and the EDA still have some flexibility with respect to that approval that was approved before if it's renewed. And if we renew it, I mean, I know I said we were willing to do it, we are, but I think maybe that's not the most efficient way to do it either, to have a new application with a new award and have that other award that's already been awarded go away, and then have that award be made to bionitrogen independent of the IDA. It takes a little bit of flexibility out of the pool as far as the discussions we've had before, and it takes maybe some, you know, frankly takes control away from the IDA if we do it that way too. So I don't know if that's the most. I don't know if that's the most. You know, I'm just thinking out loud a little bit here. I have not had this discussion before, but renewing it in place and then continuing discussion about how we might modify it would, which all can happen. Hopefully, will happen before August, and when the EDA are making decisions anyway. Wouldn't put us in a bad position, I don't think.
We just can't get that done before the 27th. If we're gonna propose any modification to the EDA, we have to meet on it, we have to discuss it, we have to know what it is and vote on it. We can't do that before.
But I don't think, is there any reason it has to be any modification at this point? I mean, I don't know that there is there?
I mean, really going back to the point you made, I would agree that if we just renew the application at this point, then, we still have the ability to make changes in the future by going back in front of the EDA. If the EDA did agree to award the grant directly, then their contingencies and their award might be different from ours, and then it just kind of becomes a little bit difficult if they're going to award that directly and we're not going to manage that process.
If we're going to renew it, we need to recognize the name change of the company. I can't recall if bionitrogen is even specified. Is it a rail spur for bionitrogen, Christie, or is it? I think that needs to be recognized, but we may want to go back and, if it's site specific, make it site generic and just admit to the IDA that, not admit, just acknowledge to the IDA that we would come back at a later time if the site changes and specify a site.
Do any of the board members have any issue with that generality of the site name change and the application renewal?
It's my understanding that they wanted this part of the process to move along faster than that. But if it doesn't matter if it happens before the 27th, then I think that works.
So, Ken, do we need a motion to direct that application?
Yes.
Yes. So we're looking for a motion to make those modifications mentioned for the name change and a more general site location in Hardin County to go back before the EDA on the 27th. Do we have a motion for that?
Clean it up in the renewal. I'll make that motion.
Second. So it's been motioned and seconded by Doug and Dottie. Any further comments from board members? Any public comment? If not, all in favor? Anyone opposed? Motion carries. Before we get into project updates,
Can I follow up on just
I wanted to say, if you don't mind, take 30. the handout that you gave this morning, list of government awards, incentives, resolutions, and letters of commitments, it was conspicuous to me that you left off what I consider very generous tax incentive, tax abatement in Hardy County. An 80% tax abatement that we voted on and approved many months ago was not even listed, and it's also the highest and most gracious tax abatement that's ever been granted by this county. And my feelings are hurt.
Well, I guess, I think the intent was that application was presented for you all, assuming that was.
Well, just don't forget we did.
No, I understand, it's not been forgotten, that's for sure. But I guess that it was an omission, as assuming that this was for extra. I appreciate you reminding us of that. I just wanted to follow up, I do want to make sure that we have a plan going forward on vetting, and that we have the proper expectations of what it is that we're supposed to do and bring to the table. And as well as coordination on some of these extra county, not extra, but out of the county statewide incentives, and moving forward on some of those processes as well. I mean, can we get some direction on that as far as how we can be moving forward on that and spending time efficiently to make that process move forward?
I think, really, our action is going to be precipitated by your action. At this point, we have an allocation in place, and, until you formally request something different, that's the award agreement that's in place. So, for us to now move into a vetting process, I feel like you guys need to come back to the table with, what change you want to make, because that initial award did not include the vetting process, and it was to use those monies at the end of the bond funding. So if that is going to change, I think that your action would encourage movement on our part
Okay.
to have that
Well,
discussion.
then what's the process for that? What's the formal application for that? I mean, where's the procedures and processes that we follow to make sure that happens? I mean, we come to the board and we talk and we get, well, we don't know, and we need to see X, Y, and Z, and I just want to make sure that we're in a process that gets us done, as opposed to, asking to be on the agenda and coming here and talking and then not knowing where we are, necessarily what we can do to make something happen. I mean, if I'm missing something, then I guess maybe I'm missing something, but.
Let me say this, Stephen. We semantically refer to projects in the IDA. We have our own projects that are not projects defined in 159. There is a full list in the statute of hoops we need to go through. And my comments earlier are that I want to make certain that we fully satisfy the expectations of Chapter 159 relative to those real official projects that are for bonding, financing, and refinancing of projects. And there's a whole list of the projects. I don't know how many are there, maybe 200 that are listed in the statute. Yours is listed there. But once we get through that process, that is my concern. We've had a preliminary vetting. If it was just the vetting that was done was simply predicated on the million from the EDA and the million from the IDA following I believe it was 175 million at the time.
The initial test for approval was
So
175.
now we're looking at leaving that money on the table in some fashion. How it is dispersed to the project, if those terms are going to change, then we have to have an internal vetting, and this board has to say, we are going to advance the money to the project. We're not necessarily going to see your $300 million on the table before we disperse our $2 million. But currently, we don't put any money in until yours shows up. And that has been used as a security to satisfy any risk that this board may have. So there's really two types of vetting that must occur. If you're going to change the $2 million ask, this board needs to discuss it and decide whether or not, how it wants to vet that. The other is the formalities in 159.
And so that was my question. How do you want to vet a
Well,
request
I
and a
mean,
change? We've asked to change
today, we have no indication that there's going to be a change in the ask of the $2 million.
We've discussed that. We've discussed it in previous meetings that we wanted to look at a framework to advance that, convert to a loan structure or some process that that meets the criteria of the board, but I don't have, I mean, I don't know what that
But
is.
if that's the
still.
case, then we have to do that in the EDA application because it's predicated too on you bringing your money to the table.
Correct. I mean, the process that we have taken forward, we had a agreement with the IDA, that the IDA said we're gonna use the EDA money to supplement, to bring the money to the table, but the only award that BioNitrogen has received is from the IDA.
So are you saying specifically that BioNitrogen would like to have a total change in circumstance of the $1 million from the EDA and the $1 million from the IDA? Do you want it to come without the contingencies of you bringing your money to the table first?
Yes.
Then we have to address that in the application process.
Where's the application? What
To the
application do I have to
EDA,
fill out?
we've talked about a renewal.
I mean, are we talking in circles? I'm not sure if we're talking about the same thing here, because I'm getting confused.
Stephen,
as to
the
understand
EDA
what-
money too is conditioned upon you bringing your money to the table.
I understand that.
Well, if we're going to renew this application, then the EDA needs to be apprised that there's going to be a change in the disbursement expectations.
I understand that, but we don't even have a change in our grant award agreement with you all yet. I mean, that came first. The EDA money was awarded. Let me just make sure I understand. I'm trying to get clarity here. EDA approves an award to the IDA of $1 million, not associated with BioNitrogen. Whatever date that happened, I don't know when that was. Probably August of 2011, 2012. IDA does a grant award agreement with BioNitrogen in December of 2012 that says we're going to have a $1 million grant. Well, the source of our $2 million grant award agreement to BioNitrogen is $1 million of IDA funds, $1 million of funds the EDA has awarded to the EDA. This award agreement is contingent upon EDA approving that structure. Okay, EDA approves a structure, it's done. So that's what we have on paper today. That's been the way it's been since whenever the EDA met to approve the amendment to the IDA award. So I think it only makes sense that the point of beginning to a modification starts back with the IDA. It's our grant award agreement between BioNitrogen and the IDA. It was a contingency in that the EDA agrees with it, and they did. So to modify it, I would say that following the same logic and process, there would be a contingency, and whatever we come up with, the EDA agrees with it. And if they do, they do it. If they don't, then we have to do something else. I mean, and if we want to have appraisals and things like that along the way, I would say that's great, and we should, but I don't think we have to go to them to ask them if we can modify our agreement to modify it and come back and ask them if they agree with it. I mean, it just seems like we're getting convoluted a little bit here. And I don't know where to start. I still don't know, what do I have to do to ask to do a modification?
Okay.
I've asked, and I'm told I have to ask.
And I'd like to address your concerns. But first, I'd like to address the board. Donald, I'm concerned that you've made numerous comments during this period of time after disclosing that you have a conflict. I'm not certain that is advisable. I don't think that if the comments that you make influence the board, that would probably not be a good recommendation to continue those comments, and everybody can hear them. So I would just like to ask that we have some decorum moving forward and try to have some structured debate. Stephen, going back to your question and your concerns, you have come and asked, and I think that the direction that we agreed on was we need to know that we have some form of security in the event that this plant does not take place, that we haven't spent $1 million of our money, and we don't have purview to spend $1 million of the EDA's money outside of how they initially awarded it. So, we ask for solutions, bring back solutions on how we can be certain that we're not gambling $2 million of Hardee County's money. I think that there was a lot of comment on the board's part that we did not want our funds to be used to pay for costs that were not actual development on the property. I know there was some debate on hard cost, soft cost. Basically the funds that we're going to be looking at are going to be, similar to what the bond is going to look at funding. I would say the exception to that would be like attorney's fees, engineering fees, those types of things. Those are the types of things that I don't, and please, any of the board members that have a different opinion, please speak up, but I don't think that that's what the intent of the board was. I agree with Mr. Coleman and the recommendation about the property, and, you know, I think that that was proffered at the last meeting. You know, is there a way that we can have a security interest in the property that the rail spur will be on? I know that, you know, they have offered to allow us use of the rail spur when they are not going to be using it, and they're gonna allow us to control that, you know, free time of the rail spur and schedule that as needed if there's additional development in that area. So if there were a way to tie, you know, our interest to that, I think that there was a lot of debate back and forth at the last meeting. I don't know if you all have proffered a solution to Bill, but if there's a solution on the table, since you know what our concerns are, that we cannot just front that money to be spent on soft costs, that we don't have a guarantee that that plant will ever be built. Does that make sense?
No, I understand your personal concerns on that, and
I'm
that's
not-
one
not
thing. That's one thing,
concerns.
and
I think it's the concerns of the board.
Okay, I mean, everybody's spoken for themselves, I know. I still want to know I mean, we got to the point where, okay, we got to do vetting on this. And so what I don't want to have happen is, I need to know what this process looks like, and how do I start the process? And I guess I don't know that there's an answer to that question. And that's concerning anyway, for a lot of reasons. But if we have an application, so I mean, I guess let me just back up here and say, so what you're saying is we need to put together an application that you may or may not like, bring it to you, and then let you tell us what you don't like about it, and then we have to go through vetting. Is that basically what I'm looking at? I mean, because I want to try to make this happen at one time if we can. I mean, the vetting has been an issue that is out there as well, and so the discussion of what's an appropriate inducement for industrial development is one conversation that we have to have, I know, given some of the concerns that have come up in prior conversations. But the flip side of that, or the other part of that, is the vetting as well, which is really a different animal too. I mean, so I'm trying to figure out from the vetting standpoint, how do we make sure that process is moving forward, where we don't get down the road and say, okay, we can like that if we have vetting, and then we start a 6-month vetting process, and then there's no sense in us starting because that doesn't work.
If there were security, then we wouldn't be discussing vetting. I mean, if there was security interest for Hardy County, so that we could be protected in the $2 million investment, I don't think we would be discussing vetting.
Madam Chair, may I take a stab at this? I understand where Stephen's going, and why he's going there. This IDA has never issued bonds. When this process started, it started as we've discussed, $1 million and $1 million. The IDA's $1 million contingent on the EDA's $1 million. But it wasn't a project under 159. And that's the essence of the debate that I've had with Frank Kirkland over and over, whether or not something's a project, and ultimately the Attorney General opined on that. The issue, as I see it, is there isn't an answer at this point to the question. That's what I hope to get to with outside counsel. When the nature of the agreement is perhaps evolving from we're going to distribute $2 million pro rata after someone else has issued the bonds, and there's a trustee sitting there making disbursement of construction money, and there's a 175 million or whatever the number was at the first time being distributed over a period of time, and if they distribute 10% and they make a $17.5 million distribution for construction, you're making a 10% distribution of your $2 million. So you were making a $200,000 distribution at the same time the trustee was releasing 17.5. That process in and of itself has a built-in vetting process. There's a financial institution in that instance that's serving as a trustee that's making certain that their $17.5 million has gone where it was supposed to go. They have inspectors, the construction's going on, you have a built-in vetting mechanism to protect your interest. It changed from that in one way, that now what's being proposed is that you're the issuer of the bonds. And that's a completely different horse. I understand why. I understand There are 2 other counties, and we're probably all competing for the same thing. We want the jobs. But when the horse changes color and it goes from someone else issuing the bonds to you as the IDA issuing the bonds, then the 159 language I've argued with Frank about comes into play. You now have an obligation under 159 to do all the financial vetting and all that stuff, because this is a 159 project, and we're in that whole different arena. We don't have an application. I don't think there's an answer to your question, is what I'm telling you. We don't have an application for a private activity revenue bond issuance by our Industrial Development Authority. Never done it. This came fairly quickly, came up just a couple of weeks ago. It's sitting before us now. I do not know, and I'm hoping outside counsel can tell me, if Deutsche Bank is going to lend $300 million on this thing. I'll promise you it will be vetted. They're going to look at every single rock and turn every rock upside down, and they're going to be comfortable that they hand their money to a trustee who is another financial institution who is going to be dispersing the money on certain milestones. I don't know to what extent you can legally, in Donald's favorite term, piggyback off Deutsche Bank's diligence, their due diligence on the financials. Can you just say someone's going to lend them $300 million and look under every rock? That's good enough for us? Or what do we have to do independently to satisfy the requirements of 159? Those are the type of questions that are going to be addressed in the conversation I have with outside counsel. So, in fairness, Steve's asking fair questions, but I don't have the answers at this point. That's part of what I intend to bring back to you in 2 weeks, and I fully expect outside counsel to give this resolution its blessing. I didn't see anything in it that alarmed me or caused me indigestion. But, you know, Mr. Cunningham, oh, there is, would acknowledge when you know, this is the point in time at which you designate outside counsel and special counsel and all that stuff. There are blanks in the resolution for that purpose. So, you know, Donald, contrary to your thoughts, I mean, the process of just adopting a resolution today, and it has blanks in it as far as who we're going to use as outside counsel, and that person is then designated through the process of being the counsel. When you get to one of these bond closings, and I have been there before, Mr. Cunningham will tell you there are stacks of documents like this that stacked up on the closing table, and your chairman, I'm assuming, is going to be asked to affix her signature to those, and she's not going to want to do that without the opinion of someone qualified who says, I have reviewed all that and you should be comfortable signing it. That's all this is about. It's a couple weeks. This thing just came up very quickly, and the color of the horse changed in such a way that it just it's incumbent on us to at least have outside counsel look at it, bless it. And in the meantime, Steve, we're going to have to just develop what that process is. Because we don't have an application for revenue bond vetting or anything like that. And I'm not certain to what extent we can rely on the lending institution in a bond issue to do that vetting.
Ken, I concur with what you're saying relative to 159. However, there's 2 other vetting criteria circumstances that need to occur. If this board is going to place its money into this project, and the circumstances of that placement into the project are going to change from them bringing their money to the table and ours being dispersed on a pro rata basis, we have to find a way to satisfy that that is an appropriate action for us to take. Similarly, I sold the EDA on placing their money into this project with the same argument, that it would not be at risk because it is coming with their money. And at the end of the day, someone's going to have $175 million in the project, and we're going to have a rail spur to that project with a right to control that rail spur won't be monopolized, and it can be used for the other pieces on the property. If those circumstances are going to change, both the EDA and the IDA has to have a process independent from the vetting that satisfies the requirements in 159. And that's the part that I'm not certain how we should do.
I understand, and, you know, it's a different, and they're not necessarily connected to one another, and I agree with Steve when he said that the bond issue thing can proceed on one way, and you can go back, and if it takes 6 months to figure out how you're gonna deal with the other 2 million, then it takes 6 months. And there may be some crossover between the two in the vetting process in terms of what's produced to satisfy your requirements under 159, maybe also used to satisfy whatever you're thinking under the local IDA, EDA requirements.
Stephen, what is your ask? What is the change in your ask from what it was to what you'd like it to be?
The change in the ask from what was approved in December of 2012 and to what we would like it to be now is for it to be money that's dispersed ahead of the bond. Now, the structure of that, we can work on that, but we've had that discussion, and I understand if you want to be fully collateralized and there'd be absolutely no risk, then there's no point in us talking to you, basically, because we'll go borrow it from somebody else. I mean, we'll go borrow it and not have to come to public meetings and deal with all this stuff. I mean, frankly, I'm just to be honest with you. I mean, we're here because this is a project. There is risk involved with it. There's risk involved with everything. This is a project that is an economic development project for Hardee County, and this board is the way I see it, and the way our client perceives what the point of coming to an IDA, or this IDA especially, is to provide an inducement for them to build their project in Hardee County and employ people in Hardee County. So I'm not going to try to minimize that. I mean, I'll be honest. I mean, if they could fully collateralize a project and say you have 125% collateralization on this project, then they can borrow the money for a couple of percent from a commercial lender. I don't know how to be more blunt than that. So,
Well, the biggest difference is that this money is not money they would need to pay back. I mean, us asking for security interest in a piece of collateral or real property, it's not the same as borrowing the money from the bank. It's money at the end of the day that when the plant is built and they have achieved the terms that they agreed to do, then our agreement disappears. But if they borrowed the money, that would be an actual debt that they would need to repay. But I don't think it's unreasonable for us to ask for.
Well, and that's part of the concept that we have internally discussed, is providing a pledge of assets, or a guarantee of repayment up until the time when the project is actually built, and then it converts into a grant. So these are concepts that we have discussed. And I'm sorry this turned into such a vigorous debate. I didn't intend for it to be that way, but I simply wanted to, I don't know. I truly just don't know how to say this is our project, and how do we get to the point where there's going to be risk involved. You're going to need to do vetting on it. I don't know why you wouldn't. So to say that, okay, well, we might not need to do vetting if we can get the project, if we can get the application to a certain point, we don't know the answer to that question either. So I want to make sure that we're doing everything we can on our end to move things along. And that was my initial question, was what is that first? What do we need to do to move things along? And I want to make sure we're moving along on everything we can move along on.
Well, I think you've done that today, because you have now changed your ask. I mean, you did this several months ago, and the board left it, come back to us with a proposal. We never got that proposal. You're back again today saying we want an advancement of this money. We want the EDA application modified to be advanced to the project. So we're going to have to agree to change the EDA application for an advancement. And then this board needs to debate under what conditions it will advance money to you for this project.
Okay. So the vetting aspect of it is that something that we can work on now? I mean, is that something we can be taking action on proactively?
I think it would be helpful. I think for me it would be helpful if we completely understood what your proposal is, what your exact request is, and if you intend to collateralize it in any way. And then we understand what the risk is to us, and we understand what vetting we should do. Because if you come in and you say it's going to be fully collateralized some way, then we may choose not to vet, or vet very diligently. If it's not, then we may have to go through a more aggressive thing. But the thing that's confusing me, at least, and I won't speak for the whole board, is I don't understand exactly what this proposal that you guys are making is going to look like. What you want to actually have as conditions on the money, getting it up front versus, you know, the grant that was originally approved. So
Okay.
we really need to understand exactly what you want, how it needs to look, and then I think we're in position to address it.
I think the intent today was to come up with regards to the inducement resolution and have the board instruct us with the path forward to sit down with the EDC to develop exactly that. Because part of this, if you look at what we've done in the other counties, it requires a development authority, it requires city managers, it requires city boards, it requires the county boards, depending upon the situation. In Taylor County, the city of Perry provides the water and they provide the natural gas. There are specific parameters that we need to go to the city on with regards to that. The city has also provided a $5 million loan that is repaid with the Deutsche Bank closing, because ultimately they're going to have a new customer that provides benefits to the city as well as the county. So there is a case-by-case situation.
Is that loan advanced to you?
It will be. So,
They will give you money before the closing?
yes, sir.
Yes.
In the case, the intended ask of this board is that the $2 million loan, and I don't want to get into the specifics and mechanics because I'm not a lawyer, of the IDA, the EDA, and how it came about, right? But the intent is the $2 million that was directly rewarded to BioNitrogen for the plant here, that it would be a loan, and that loan would be converted to a grant upon financial closing. That is the intended ask. But part of that is that we need to go ahead and specifically select the site. We need to move forward with the power, as you mentioned, either we do pre-co or we self-generate. We move forward with the gas company. We move forward with the city. As an example, do we drill wells, which creates no economic development for the area that we're going to move into? Or do we work with the city to provide water through the county to our site, which would provide economic development for the area? Those are big issues, right? And if I sit here and say, we're going to spend the money on the site, and the Hardy County has tools in their toolbox that they're not willing to use for us, then we'll go to another county that's willing to use the tools. And that's what we're here for. Is we've used these tools in other counties. And you have a tool in your toolbox, which is the funds that you have available. And we are looking to you to create 52 jobs, over $1 million in taxes for the school system. And other counties love that. And we don't understand why you would not love it as well. So the intended ask, which we've gone through back and forth a couple times, converting the grant to a loan, so there is some form of security. There's a guarantee from the parent. We have assets of $15 million that have been appraised from patents. There's a patent pending and a patent awarded. There's a third-party independent appraisal from an accounting firm that values that at $15.4 million. We have assets. Okay? So that's the specific ask that we want to get to it. We're happy to do the $2 million loan that's converted into a grant upon financial closing with Deutsche Bank. That's the specific ask that we were planning to put in a package that Stephen would communicate through the management to the board.
Let me go back
Sure.
and clarify a couple points with you, if I may. The $5 million loan with Taylor County is currently a loan that my understanding was to be repaid to Taylor County from the bond proceeds. But the loan was for plant engineering and initial cost. Is that correct?
Correct. It is for what you call pre-development costs or costs prior to the financial closing with Deutsche Bank.
So are they intending to convert their loan to a grant at the end?
No.
So then, in essence, what we're offering you is a better incentive in addition to the 80% tax abatement. I mean, I think that, it sounds to me like our proposal between the EDA, the IDA, and the county and what we're offering is a fairly generous proposal, and I don't think that anyone has expressed that we're not interested in the project and interested in moving it forward. But, you know, in fairness, our $2 million grant is a grant. It's not a loan that's intended to be repaid.
I don't disagree with the concept, and I was there, and as I said, this is a package, right? So if you look at your 80% in isolation, we have 90%